Welcome once again to our continuing YouTube video series on business and corporations. My name is Christopher Neufeld of Neufeld Legal, and in this particular video we will be discussing the duties of a corporate director. Now we'll discuss first the 6 key points and then we'll address each of them. So the 6 of them are a duty to manage, fiduciary duty, a duty of care, business judgment, conflict of interest, and oppression. Now, the duty to manage pertains to management of the overall company. And this is from a big picture perspective that they are required to oversee the management of the company, delegate the responsibilities of day-to-day operations to the officers, and through the officers, the employees, the managers, and the like. And then meanwhile undertake a range of supervisory roles, including accounting and audit, compensation, human resources, technology transfer, major transactions, and the like. They are overseeing them. They are not necessarily undertaking them. They make determinations on the highest level with respect to their activity. That is their management duty. Next, they have a fiduciary duty. And by means of a fiduciary duty, they have a duty of loyalty towards the company. They are empowered and required to safeguard and best pursue the interests of the company in a legitimate and forceful manner. That is their fiduciary duty. They assume that role by taking on the position of a director and thereupon are charged with carrying out that role faithfully and honestly and in the best interests of the corporation as opposed to their own independent personal interests if they intend to be serving as a director. Next, they have a duty of care. The duty of care relates to their need to manage aspects to a standard of behavior that would be expected of someone of their stature. And being a director of a company, which is a very prominent position, that standard is quite high. They are expected to look out for the best interests of the company. They are expected to ensure that the company is not only faithfully serving its own agenda, but faithfully serving the law and exercising its role within the confines and in conformity with the law and prevailing regulations and whatever contractual matters that they are legitimately required to uphold. Next, directors are expected to adhere to the business judgment rule. They are supposed to undertake matters of business in a critical fashion, making smart and intelligible decisions that reflect a knowledge of what needs to be done and a need to advance the business of the corporation, as opposed to the interests of others, including their own personal interests, given that those personal interests might well strike adversely against those of the corporation. They need to make sure that they are informed, they understand their responsibilities, they look into stuff, and when they are at a disadvantage with respect to knowledge or insight, to look outward and to draw upon whether it's professionals and others in their own sphere to best advance the interests of their corporation. Next, and we've already touched upon this aspect, they have a duty to avoid conflicts of interest. The fact of the matter is, by joining into the board as a director, they are undertaking to put the corporate interests and the corporate knowledge that they have and the opportunities of the corporation that they are serving in first position, as opposed to taking advantage of their internal role to take personal advantage of matters to the detriment of the interests of the corporation. As such, when business opportunities arise, they are required and expected to advance the company. They are not expected to try to pursue their own personal interests to the disadvantage of the company. And when there are the potentials for conflicts between their own personal interests and their own interests, they need to be soliciting legal advice to ensure that the proper action is undertaken to preclude any occurrence of a conflict of interest. That either they step away, they remain impartial, and they are not brought into a position where they adversely impact the company that they are serving and that company's interests and financial pursuits. Finally is the aspect of oppression, wherein directors are expected not to oppress the interests of their shareholders. They are not expected to take advantage of their higher position, especially given the fact that many times directors are also shareholders in a particular company, such that their additional power that comes with their ability to formulate, direct, and guide the operations of the company and its policies could be brought to the disadvantage of other shareholders, in particular those shareholders that are not sitting on the board of directors. So there's an expectation that with heightened stature in the company, they are not supposed to take advantage of that heightened stature to the disadvantage of the other shareholders, in particular being those who are minority shareholders and who lack the ability to oversee matters, to understand what is taking place at the board of directors level, internally at the corporate level, amongst the officers which the board of directors are reviewing, and seeing where matters are being planned and going forward and have not necessarily been properly disclosed to those minority shareholders. So to go over these 6 key duties that one must consider as a member of the board of directors in one's capacity as a director, one has the role of the duty to manage, a fiduciary duty, a duty of care, business judgment, an absence of conflict of interest, and an avoidance of oppression of other minority shareholders. And that represents some of the core duties and responsibilities of a corporate director. I trust this YouTube video has been informative, and for matters pertaining to corporations, incorporations, and the like, please do not hesitate to contact ourselves, as this is our core area of legal practice. Thank you very much.